disabled or having a long-term health condition or a very serious neurodivergence that impacts your life to the point of adversity that you require things like personal independence payments and maybe other benefits, has become somewhat of a job. And I've got a really interesting comment here from one of my lovely followers here over at the Justice Journals. Thank you so much for subscribing. Who said, when I was going through my health planner or my health journal and how you can use this to evidence your disability and the impact that it's happening, that it has on you, the person's commented, what they'll say about that evidence journal is if you're capable of keeping that, you're capable of doing an office job. And this is a very interesting comment. So in this video, I'm going to be breaking down how you can make sure organisations like PIP and DWP do not weaponise your disability against you in the way that this person is suggesting that they do. And yes, you're quite within your rights to think that they would say that. I had DWP's barrister tell me that, or tell the court, that there is no way that I could be have a disability because I'm too intellectual. Like, that came straight out of their barrister's mouth, I kid you not. So obviously she was corrected rather, swiftly. And I'm going to show you or talk to you about some of the things I've learned in my legal case that helped me. This is not legal advice, but it might be a good place for you to start getting some more information if you want to defend yourself against these sorts of completely bigoted, senseless claims. So quite simply, when someone is using something like My Health Journal to track their disability, record fluctuations in their health, record pain thresholds, record medical appointments, record professionals' notes, images, x-rays, photos, receipts for supporting disability aids, etc., etc. That evidence, it is therefore evidence, exists because of disability. Crucial point in law. So to then say, oh, if you can fill that in, then you can do a job, is classic discriminatory inference, and it's actually not allowed in the UK law. Shocking that we have to point that out to organisations like the Department of Work and Pensions, but we are where we are. Now, I'm going to point out, in my opinion, what I think, or why I think a comment like that would be, or could be, if represented well, be classed very well as being discriminatory inference, are because of these things here. So when we're talking about adverse effects, and we're comparing that to having the capability, even through disability or through a cognitive issue, or a long-term health condition, we're talking about somebody who can do that job or can do those activities consistently, repeatedly and safely. So to say that someone can write, take a minute or two to write in a planner is equal to a full-time job or a part-time job or an 8-hour or 4-hour shift of employment is not at all the same measurement, and it is a completely different stack of ratios. So it is a comparative that is completely void. And on that basis, recording symptoms, as you would do in My Health Journal, is not equal to being able to carry out a competitive and repetitive work. And this is exactly why PIP, limited capability for work and no work related activity, and reasonable adjustments all use the same concept of reliability, safely, repeatedly, doing something within a reasonable time period or time frame and as often as required. And the whole of that health journal is set out to literally frame your health condition to fit into these boxes. So if it does fit into these boxes, then by what score? Because they all use scores when they are doing your assessments. And most importantly, a planner records the fact that you can't do things reliably. So it's recording unreliability, not capability. So I have used a Justice Writer Pro, the software that is available over at the Justice Journals for all of our insider members, to come up with a very nice outline of a type of letter that I would write if someone were to challenge me about filling in my own health journal for my own disabilities and my health conditions. And it even brings up the sections of the Equality Act that this could potentially break. So the first one, and probably the strongest one, is section 15, discrimination arising from disability. And again, I'm going to shock you here with an example. Because you were able to write in a planner, you can work. I actually had to deal with the employment judge saying to me, or writing in one of their orders, that because I was capable in October to do something, then I should have been, or could have been, capable in August. Doesn't quite work like that in a disability, and these are the reasons why. Because otherwise we could just, fit any narrative into any kind of concept and have it be applied incorrectly. So quite simply, if a work coach says something like, well, you can write in a planner so you can do an admin job, it is just so wrong. Because I've put here, section 15, because you were able to write in a planner, you can work. This is something in this particular example that arises specifically from your disability. So your symptom tracking, your memory aids, and your coping strategies. To say that you can work because you can do that is treating you unfavourably on the grounds of disability, and therefore it is discriminative. So the same comment also, section 19, indirect disability discrimination, would also fit really well with this type of a comment. Because technically what that person, DWP employee or someone, is saying is, well, if you can organise yourself to write in a journal, then you can organise and deal with different symptoms at work. Now, if that were the case, you could say, well, that is a policy or a criterion that disproportionately disadvantages me as a disabled person or a disabled claimant. And the Equality Act of 2010 exists specifically so. People with disabilities or long-term health conditions are not disadvantaged. This is perhaps one of my favourite ones because it seems like every government organisation, like the Department of Work and Pensions, even the judge who sat on my employment tribunal, failed to make reasonable adjustments. I mean, shockingly so, in a discrimination case for disability. I just still cannot get my head around it. But what employers, organisations like DWP, PIP, employment tribunal judges need to remember that it is a breach, a clear breach of their duty not to make reasonable adjustments for a disabled person should they request it. And what that actual reasonable adjustment is needs to be defined by the request of the disabled person, not a judge. So if a judge says, well, I've given you the right to attend virtually, you've got your reasonable adjustment, well, that's not perhaps what you would have asked. So they have to be very careful on these grounds. Going back to organisations like PIP and DWP, as some of you are worried about this, and in this case, we would look on the job centre, your work coach, PIP really, in a sense, to be an employer. So when we say here, if it's an employer, think of those organisations, with this wording as the employer. So if it's an employer, it is a clear breach of their duty to not understand your condition properly, and to not seek occupational health advice, and to avoid assumptions at all costs, because otherwise they could show prejudice, or their comments, such as this one here, could be classed as being discriminative. And also they are mandated to adjust work so that it is manageable. So that's the law. But applying that to this particular example, you could say, or you could state, if that person is assuming you're able to do an office job because you managed to write in a planner, that removes the duty to adjust, which is, as we've just seen, unlawful. Now, I've actually got another section 26 and a few other sections as well that would apply to this, but I think I'm going to stop there at 10 minutes. Let me know if this has been helpful for you, and please, you lovely disabled people, you people suffering with chronic illnesses, stop living in fear of these organisations dictating to you in this way. Nobody asked to be disabled. Nobody asked to be so ill that their illness is chronic and defines them as disabled by the Equality Act of 2010. You'd have to be a very odd person to want to be voluntarily disabled. So take pride in the fact that you have rights as a disabled person. Take pride in the fact that you are educating yourself about your rights as a disabled person, because you do have rights. And take pride in the fact that in some cases you may know the law relating to your particular situation better than some of these organisations that are taking taxpayers' money to be paid to do a job pretty bloody poorly in lots of examples. So take pride in the fact that you're not one of those people. You are acting reasonably, and you are acting with a duty of care, mostly to yourself. So yes, just know that. Love you all and have a great day. And yeah, get my planner, guys. I will say, get my planner, because you should not feel that you can't record your disability or your health conditions for fear of comeback. It's just insane. What an insane thought. But I understand why you think like that, but you mustn't.